Hello and welcome. In this unit, we'll discuss the various steps that happen when a parent goes through the IEP process. We'll pay particular attention to the laws that govern these different steps. Our goals in this unit are to 1. Explore the laws related to the IEP process, and 2. Learn strategies to ensure that these laws are meaningful to the IEP process. Why is it important to learn the laws with regards to the IEP process? Well, because an IEP is a legally binding contract between you, the parent, and the district, it's important to know what laws apply during the IEP process. So if there's a conflict, you know what your rights and duties are. While parents might not think of the IEP as a contract, the IEP is basically a contract similar to what you would sign when you rent a house or buy a car. Later on in this unit, we'll see why this is so. But for now, remember that you, as a parent, have to become comfortable reading the IEP as a contract and making sure it's carried out according to what was decided at the IEP meeting. Now that we know that the IEP is a contract, let's discuss the laws related to the IEP from beginning to end. Okay, the first step of the IEP process is knowing that an IEP meeting will take place. In order to have an IEP meeting, the school district must send out a notice to the parent regarding the details of the meeting. This should include the purpose of the meeting, the time of the meeting, location of the meeting, who will be in attendance, notice to the parents that they may bring other people to the meeting who have knowledge or special expertise regarding the student with special needs, and if a student is 16 years of age or older, an invitation to that student to attend the IEP to discuss transition goals and services. Why are these notice requirements important parts of the law? Well, remember, parents are a vital part of the IEP team, and parents have to be able to attend and participate in IEP meetings. Without proper notice, parents may not be able to take time off from work or juggle childcare in order to attend. The law recognizes how important parents are to the IEP team and wants to make sure they have an ability to attend. However, note that nothing in what we just covered states the school must give a specific amount of time in terms of notice. There is nothing in the law that requires a school to use a specific timeline. That means that schools are not required to give parents 10, 20, or even 30 days notice. The law is silent. While some districts may have policies stating that all IEP notices have to go out 7 or 10 days in advance, this may not be the case for your district. If there is no formal policy, then you would be working with what is reasonable. For example, if you get a notice saying that you have an IEP meeting Friday at 7 a.m. and today is Thursday, that's probably not reasonable. A parent should always document any time this happens. If a parent has to decline an IEP meeting because of short notice, they should do so in writing and state that they couldn't attend the IEP meeting because of the school's scheduling. In addition, the law we're discussing states that the IEP meeting must be scheduled at a mutually agreed upon time and place. Again, the law does not give specifics, and what this means is somewhat open to interpretation. Could the mutually agreed upon time and place be 9 p.m. at a bar? Well, yeah, technically, though more likely, and probably advisable, is to have it at the school during school hours. However, if the time doesn't work for a parent, maybe because of their work schedule, the law allows a parent to ask for some sort of accommodation in terms of scheduling the IEP meeting. Likewise, if the location doesn't work for the parent, they can also ask for a different location. For example, if the school wants to hold an IEP in a school library or an open conference space, you might want to argue that your child's privacy may be at risk. Since the space would not be mutually agreeable to you both, the school should find a new location to hold the IEP meeting. Okay, let's continue with the IEP process. Now we're actually in an IEP. What laws apply here? Many parents ask whether they can record an IEP, and the answer is yes. A meeting can be tape recorded, but a parent should give 24 hours notice to the school. And of course, in no way should a parent record the IEP without the school knowing, as a parent may face criminal penalties. Of course, knowing that you can record the IEP doesn't necessarily mean that you should. I wouldn't recommend one option or the other, but parents should think about the pros and the cons. Think about what may happen if you decide to record the IEP. You would definitely have a better record of what happened, and you wouldn't need to take notes if you didn't want to. But what will happen when IEP team members know they are being recorded? Will they freeze up knowing they're being recorded? Some parents want to record the IEP meeting as evidence, assuming they will go through due process. And yes, recording could be helpful in ensuring that what was said at the IEP is memorialized. But again, think about the issues that may come up. What you say may sound different when IEP recordings are transcribed for due process hearings. Will someone reading what is said get the tone of what was said? Think about a phrase such as, "They'll get what's coming to them." Tone changes the meaning drastically. Another question that often comes up is who actually is supposed to attend the IEP. That is, who are the IEP team members who absolutely have to be present at an IEP? This is different from the IEP team members a parent wants present. Who should attend includes, by law, the parent or parents, the student if appropriate, an administrator with authority to make decisions, a general education teacher, a special education teacher, an assessor, which can be the actual assessor or someone who can interpret the assessment results, and an interpreter if necessary. In addition, at the discretion of the parent or the school, other team members might be present. For example, a parent might want service providers present so that they can chime in on the progress the student is making with the services they're receiving. Let's discuss why some of these people need to be present at the IEP meeting. The general education teacher is often one required IEP team member that stands out for most people. They say, "Why would a general education teacher need to be at an IEP meeting if my child is in special education, especially if they're in special ed all day?" Well, first, a student who is in special ed may be in a general education classroom with supports for some portion of the day. This is a placement issue we'll cover in a later unit, but it's important to have a teacher there that could explain the general education placement for the parents and the student. Their input would be helpful if a student is to be moved from or to a more restrictive environment. General education teachers can also help guide parents in terms of standards and developmental needs of students who don't have disabilities. Okay, now let's talk about the administrator. The key here is that this person should have decision-making power. Basically, this person should have some control over the purse strings of the school. For example, if the IEP team agrees to provide 60 minutes of therapy instead of 30 minutes, then the administrator should be able to okay that change and its costs without having to call someone or put off the decision to another meeting. Essentially, you want the decisions to be made in the IEP meeting, then and there. You can't do that if the administrator doesn't have decision-making authority. Of course, you can always ask for other team members to be present. For example, you might want a group home representative if the student is not living with their parents, a psychologist, such as the psychologist who did the student's testing, an inclusion specialist, the school principal, transition service providers if the student is going through transitions, or behavior intervention specialists. While these people are not required to be there by law, you may want to ask for them to be present so that they can help you understand your child's IEP, progress, and other parts of your child's program. But what happens if an IEP team member wants to be excused from participating in an IEP? Well, an IEP team member can be excused only if both the parent and the school district agree that the member is not necessary. For example, if the member's area of the curriculum or related services is not being modified or discussed in the meeting. While you don't have to get this in writing, you probably should. This way, it's perfectly clear that you excused that member of the IEP team only for this one meeting. But what happens if a team member should be present and they aren't? Well, an IEP team member may be excused from attending an IEP meeting, in whole or in part, even if the person is required to be present, if they provide input into the development of the IEP prior to the IEP meeting. This agreement should also be in writing. If an IEP team member refuses to attend the IEP and you want them present, or they leave without your consent, this should be documented in the IEP's note page. Or, if that can't be done, you should document what happened later via a letter or email to the school or district. Let's continue looking at laws that affect the IEP process. So what should you discuss at the IEP? As you know, an IEP is individualized. Remember, that is the I in IEP. So there is really no one thing that should be covered at every IEP. But things that should be discussed at IEP meetings include the strengths of the student. Remember, the IEP is a document that governs the education of the child. It should not just focus on the needs, but on what the child does well. Concerns of the parent. You are a very important team member, and your concerns must be heard. While they don't trump everyone else's opinion or concerns, your concerns as parent are very important to the IEP process. Results of the initial or most recent assessment of the student. This is vital. Assessments give us the evidence to know what is happening with the student and how their needs can be addressed. And finally, the academic, developmental, and functional needs of the student. Again, since the IEP is the document that governs the child's education, it must have all these items. We can't build an education program without knowing what a student's needs are. In addition, other considerations may include the use of positive behavioral interventions and supports, and the needs of students with limited English proficiency as they related to the IEP. Now that we've discussed the notice, who attends the IEP, and what should be discussed, let's talk about signing it. Remember, the IEP or any of its parts cannot go into effect until a parent signs it. This is important to remember because the IEP is a contract, and when you sign the IEP, you are agreeing to the contract. Remember earlier we said that the IEP was a contract, just like what you sign when you rent a house or buy a car? And like most contracts, you will sign the IEP at the end to show your consent to what is in the contract. Your signature says that you are in agreement with the terms. For example, when you sign a rental contract, you're agreeing with the terms, such as how much rent you'll pay and on what dates you'll move in. When you sign an IEP, you're similarly saying you agree with what is in the IEP and what services the school will provide to your child. Your signature is therefore very important because when you sign, you are giving consent. So please, don't sign the IEP unless you're completely sure you agree with the IEP. If you don't agree with the IEP, there are several options. A parent has the right to disagree with any part of the IEP, in which case only the part that the parent and the school agreed upon will actually be implemented. A parent may consent to the IEP being implemented, but clarify on the signature page that even though they are consenting to implementation, they do not feel the IEP is an appropriate offer of a free, appropriate public education. A parent can also completely disagree with the IEP. If this happens, then the old IEP that was consented to controls services. Remember, without your signature, the IEP won't take into effect. While IEP meetings sometimes might seem chaotic and stacked against parents, remember just how much power parents actually have. Parents are vital to the IEP process. With that, we'll end this unit. In a later unit, we'll cover in depth some of the topics we spoke about, such as placement. We'll also cover a few other components of the IEPs, such as transition plans, that we didn't get to cover today. In the meantime, here are a few resources for you. You can access our toolkit online and read Chapter 9 on the IEP for more information. If you're in the LA area, you can also call us for an intake if you're having trouble with your child's educational program. Well, thanks for joining us, and goodbye for now.